Hello, this is Mark Boyer, and this is a video on my Supreme Court of Canada filing of a mandamus, which was electronically done on December 6th, which was last Monday. And as to their rules, on this Monday, we're right now it's Saturday, okay? On Monday the 13th, we'll be filing the official CD-ROM and or DVD and paper copies with the signed affidavits, okay? And that's when the sparks hit, okay? Because then they have been officially served a mandamus, okay, which is something which has been going on for 2 weeks now. This serving process. Basically, the Supreme Court of Canada has never, to my knowledge, been served a mandamus. And as I expressed to the registrar's office twice, and in writing between both times, and what happens is the people who pick up the phone can't speak to me after that because they're bound to their duty, because I've cornered them, okay, into their oath. And the reality is I express it to them, is not anyone can file a mandamus. And I agree with that, okay? Nobody off the street can just walk in and file a mandamus at the Supreme Court of Canada. One, you need an active appeals file. You need an appeals file that is from a BC, well, I have one from the BC appellate courts, okay? So I'm acting against an active file. And the charge is a mandamus is used when a previous body, where a lower body is breaking the law, okay? I filed a mandamus in BC against the judges breaking their oath and breaking their, which is the problem. And they just fall on their feet. They don't know what to do. I did it in Alberta. In Alberta, the judge actually said the office can do nothing about it, because he refused to pick up the file. And I said, the office has no arms, no head, no legs, no conscience. That's up to you who hold the office. You have these arms. Pick up the file. And he wouldn't do it. Okay. Now that is the power of. Bottom line is, I'm attacking there's a fundamental flaw that happened in 1993, and it's the crux of my legal case. And actually, the crux of my legal case is my trial was rigged. Okay, but the reason my trial was rigged was because in 1993, the bar changed their oath to the bar. Okay, which they hadn't changed since 1559, which is the Act. Okay. And there's all sorts of things about the Act of Supremacy that are totally irrelevant, but the oath itself has held that long, okay? Now, and that's basically that God is supreme and there is no one above the law, okay? Now, the reality is they've fallen back to King Henry VIII's form, where the king is supreme and he is above the law. But they just didn't bother telling us citizens that that's the case, okay? We are figuring it out all by ourselves, okay? And people really have, okay? Now the reality is I'm filing that in 1993, they changed their oath to the bar. And I have minutes of this, okay? Where it says that some benchers complained and filed a notice to the effect that this may lead to a conflict where the oath to the bar is in conflict with the oath to the office. And they duly noted it. There was one objection, but they passed it. So the oath changed, okay? Now what they're doing is they're upholding the oath of the United States, the oath to the bar of the United States. And there really is some deep constitutional problems that could arise, and that's exactly one of these that I'm filing. Now, since 1993, a lawyer, just like they were in King Henry VIII's time, when the king was above the law, they had to be submissive. Ever since 1993, lawyers have to be submissive to the Crown. Okay, now that's just the way it is. Now, it's under what's called the supremacy of Parliament. Now, and I'm first to admit that the average citizen can't file a mandamus against the Supreme Court of Canada, or even in a Supreme Court of BC, without going through a lawyer. Okay, and a lawyer since 1993 can't file a mandamus because he's not being submissive. It's an order. Okay, the last thing that it's not an application. It's a demand note being filed. Okay, and everything else is, every other form of paper out there is you're appealing to them or making an application to appeal, and which is begging. Okay, the essence of appeal is begging, and it's the essence of my one of the cornerstones of my case is if you beg for God-given rights, then you're given the courts the option of saying yes or no to God-given rights. And Canada has an abysmal track record of just violating all God-given rights in virtually every court ruling they've ever dished out. And that's the truth. Okay? Now, the reality is in my case, okay, I have a ruling here that I got at the Supreme Court of BC Appellate Courts, not BC Supreme Court, no, the Appellate Courts of BC, the highest court in the land, which in BC. And it says here that the judges walked in and said, Mr. Boyer, this is not an appeal. And this ruling is so self-evident, we are not given it a written ruling. Okay, this is not an appeal, and then they ran out of the room. Now, the reason it's not an appeal is because it's criminal charges. Now, these judges refuse to uphold the law. Okay, now the reality is it's self-evident. Okay, my reasons for judgment, okay, was done in November, written in November 16th, 2005. And I was found guilty at my trial on December 5th, 2005. So this was written 2.5 weeks before I actually went to court. Okay? And, now, so I was found guilty 2 weeks before I went to court. And it's got great lines like, the first statement. In a reasons for judgment, the judge should be going, you dirty, rotten scum bag, you're going to court, you're going to jail, you're being found guilty because you've done this crime. That's basically the wording of what the first line should read. Mine reads, Mr. Boyer, you may not think that I do not understand your cause, that I do not understand your political purpose or your philosophy about making Canada, or even a small place where you live, into a community where everyone feels comfortable, where there is absolute freedom of speech, freedom of thought, and freedom of act. But I do. Now that's a compliment, okay? She's saying that that's what I'm upholding. Next line. But I also understand, which is a legal word, stand under is also. She also stands under that the law as decided by the majority and reflected in the Criminal Code of Canada, and the CDSA. Okay, now that says that this law was decided by the majority in power. My ruling was decided by the majority in power. What does the majority in power have to do in telling the judge to find me guilty because it was written 2 weeks before I went to trial? Okay, 2.5 weeks before I actually went to a sentence. And Section 11D of the Charter of Rights and Freedoms says very clearly, when you have been given, everyone is presumed innocent, innocent, until all the evidence is entered at a fair and impartial tribunal. And I got this ruling at a tribunal that said that they weren't going to interfere with the fact that my trial was rigged. A constituent of a recognized and federal political party The Marijuana Party of Canada may well have a mandate, the authority, and indeed the obligation to promote the beliefs of its members, which I would include among these beliefs a belief that the sale and use of marijuana for medical purposes would be illegal, would be lawful. That's what the judge says. I would include, okay, that this would be lawful. But then it goes, but they cannot do it. Now, they means either the CDSA can't do it or the majority in power can't do it. Now, neither one of those bodies can tell a judge to find me guilty before a trial. And they rigged my trial. Because it says there, but they can't do it. Even though the judge thinks I should get this, they can't do it. In other words, my trial was rigged.